All rise.
Hearing in the appeal Brave Timber Products Limited against Majesty's Revenue and Customs.
Mr. Sherry.
I represent Brave Timber Products, Appellant in this case. And I'm leading Mr. Alan James, who is my junior for today. With him is his pupil, Anne Redston.
Would you speak up a little bit?
Yes, either you've lost your voice or I've lost my hearing.
Very good, my lord. I'm obliged. Mr. Alan James is my junior. And to his right is Ms. Anne Redston, who is his pupil. We're all of the English bar, representing Her Majesty's Revenue and Customs, David Johnson, QC, and Ian Artemis of the Scottish bar. My lord, this is the first tax appeal, we believe, to the new Supreme Court.
Yes, it is.
And I'd like to take this opportunity to compliment your lordships on the input that you've had into what is a very impressive site for these hearings. It's also, as we understand it, the first appeal from the Court of Session to the new Supreme Court.
That's also true.
And the importance of the case, however, rests in that it is the first case to come before the courts at all concerning the interpretation of Part 7 of the Income Tax, Employment and Pensions Act 2003, which deals with employment-related securities. And we say it's important not only for the outcome of this particular case, but because the understanding of how market value is to be interpreted in the context of Part 7 has a bearing on many arrangements which are entered into on a daily basis in relation to employment-related securities. It's now 6 years since these provisions were enacted, and this basic uncertainty as to how the market value rule is to be applied throughout Part 7 is a matter of great importance.
The definition that's used, at least in Chapter D, 3D, which we're looking at, is the 1992 definition, which
Indeed, my
has been in
lord.
existence for rather longer.
It has been, but in terms of the problem that you're faced with today, it hasn't been considered in that context. And we will be submitting, as we said in our written case, that the context here is most important.
Yes?
My lord, just as a general point, the choice here is not between taxation and non-taxation. The choice is between income tax and capital gains tax. And if there be any bounty or employment element in the combination of the securities with which we're concerned and the subscription agreement and the rights under it, then our submission is that the right time to tax that bounty or undervalue for the employee is when he receives those rights, not when they reach fruition at the end.
You mean to say that when that should be taxed at the date when the subscription agreement was entered into?
If at that point there is an element of reward, that's the appropriate point, we say, in circumstances like this. So we are not arguing that these matters escape the scope of Part 7 at all. The argument is really whether or not the market value rule applies to tax something like these arrangements when they're acquired under Chapter 3C, if appropriate, or when they come to fruition under Chapter 3D. My Lord, before I start making submissions, I'd just like to give you an outline of how I intend to approach the case.
Yes.
And before I do that, I'd just like to make sure that your lordships all have all the relevant materials. There should be a core volume, which should include the first appendix, the second appendix. There should then be 4 volumes of authorities and other materials. And then we have a small additional
No, we don't,
bundle
we
of
don't
materials
have that yet. I think this is...
which we have notified the court we were going to bring today, and the revenue have been aware of the contents of this for a couple of weeks.
Thank you. Okay. Thank you. Thank you very much.
My Lord, the plan I intend to follow with your lordship's approval will be to look at the relevant chapters in Part 7, the first 7 chapters, which are chapters 1, 2, 3, 3A, 3B, 3C and 3D. And this may take a little longer than this process would normally take in this court, because although submissions were made on the context before the Special Commissioner, they weren't reflected in his decision. And so far as I can see, submissions of this sort were not made before the Court of Session. So your lordships don't have the assistance of the decisions below in interpreting these provisions.
Can I be quite clear? You appeared, of course, before the Special Commissioners.
I did not.
Are you saying that you, in your presentation, you did introduce an argument that covered the whole range?
I did, my Lord, and in the bundle before the Special Commissioners, the whole of Part 7 down to chapters 1 through to 4 were in the bundle. And I made submissions about the significance in particular of Chapter 2, which didn't meet with approval. And they're not reflected in the decision.
And sadly, the Council for the Revenue in Scotland is no longer with us, so we don't know, we don't have her position, her recollection.
Indeed, my Lord.
Well, that's Chapter 1, is it?
It's not only Chapter 1, but it's...
No, I mean Chapter 1 of your submission.
Oh, I beg your pardon, my Lord. Indeed.
Yes.
Indeed. The next thing I will do is then take you to the 1992 Act and the provisions there. And then we will look at the revenues frequently asked questions and answers. We'll then briefly look at the provisions in the Inheritance Tax Code, which of course nearly all the authorities on market value have been in respect of. After that, I want to take the court to some authorities on company law authorities.
Sorry, company.
Company law authorities, in particular what the textbooks say on the significance of the terms of issue of shares, there being no direct authority on where one finds the parameters of class rights. And then I will, my Lord, take the court to three authorities dealing with the implications of rights of the type that we have here in an agreement which serves a number of purposes. The agreement is an agreement between some of the shareholders. It is also an agreement between the company and Mr. Gibson, and it also contains in it the terms upon which his shares were issued. So it serves a number of different purposes. So in that section, I will be addressing your lordships on the significance of the approval of the agreement by a special resolution procedure and the significance of the particular terms of the agreement.
Is the word approval strictly correct? I thought there was an authorisation rather.
There was an authorisation, my Lord, which we submit gives implicit approval to the terms within the agreement, which were provided for an issue of shares.
The point being, I suppose, that, as I think you've already accepted, the parties to the shareholders' agreement were 83.8% of the issued share capital.
Indeed, my Lord,
so
and the company.
Not all the shareholders.
Not all the shareholders.
Certainly the company was a party too, but one has to bear that in mind.
Yeah, indeed, my Lord. But when we come to look at excuse me, when we come to look at the way in which class rights can be created and how they can be amended, the significance of a special resolution will become more apparent.
But are we dealing with class rights here? I thought there was a single class
will
of shares.
be the point of these submissions, my Lord. If we're not dealing with class rights, we're dealing with something very, very close to them.
That they're not assignable. The agreement.
Indeed, my Lord, and that will be the purpose of taking you to Cumbrian newspapers and to Harman and BML.
But your point is to say, is it that this is as close as can be to a class right? And
If it isn't in fact a class right, and I say it probably is, but if it isn't, it's close enough to get the protection of Section 459 of the Companies Act 85 in respect of unfairness.
Yes.
And having looked at the authorities there, we'll then look at the provisions of Table A, which has been adopted here by the company, and then the other specific articles, and then we'll look at the particular provisions of the shareholders' agreement at that stage. And it is at that stage, my Lord, I hope to be able to make good the proposition that the subscription agreement contains the terms upon which the shares are issued, whether or not it creates separate class rights.
It's a strange concept. I don't want to interrupt you too much, but when you use a phrase like that, one would expect those terms to transmit to purchasers.
Well, indeed, my Lord, but that is the significance of the Cumbrian newspaper decision and the Harman decision, where it's been held on more than one occasion in those two cases, and seems to be recognised by the textbook writers, that rights can be class rights where they attach to a particular shareholder.
Neither of those authorities was referred to below, was it?
I don't believe so, my lord, no.
But they're now in the forefront of your case.
Well, my lord, what we say is that our case is at 2 or 3 levels. The first level, or the highest level at which it can be put, is that the rights in question are class rights. The next level at which we put it is that, well, if they're not class rights, they are nevertheless the terms upon which the shares were issued, and so attach to the shares, if using that word colloquially.
What do you mean by attach?
Well, that they are part and parcel of the bundle of rights which are in existence in respect of the shares for the time being. Whether or not the shares will survive the coming to the end of the terms of the agreement or the fulfilment of the terms of the agreement would depend upon the way in which the agreement was fulfilled. So there are provisions in the agreement for the shares in question to be purchased by the company in certain circumstances. In the events which happened, the shares were purchased by a third party. But that was, as it were, the fulfilment and the discharge of the rights which were attached to those particular shares by the terms of issue. So, my lord, I'm not using that in a particularly technical sense, but in an ordinary language sense. And then, thirdly, we say even if that be wrong, we say the approach adopted by Lord Osborne in the Court of Session is correct, namely that the ability of the parties to change the articles.
Ability of the parties to do what?
Change the articles, so the 83-point-odd% of the parties to the shareholders' agreement who are shareholders have the ability to secure a special resolution and change the articles, to which, of course, is added the shares issued to Mr. Gibson himself, taken together with the fact that the company is itself a party to the agreement, mean that it is inevitable when somebody such as Gibson's were going to buy the whole company, all the shares, they would be ready, able and willing to pay a price to Mr. Gibson which satisfied his entitlements under the agreement. Because if they didn't, in acquiring the company, they would be in effect buying litigation.
The position is that Mr. Gibson couldn't, because of the numbers of shares he held himself, carry through the special resolution. But you're saying that those who are tied into the agreement with him would be obliged to go along with his request. Is that how it would work?
Well, if a special resolution were needed to give effect to any of the terms of the agreement, then he and the other parties were in a position to pass one, and if the other parties didn't, then they might be at risk, if such a special resolution were needed, of failing to procure that which they've contracted to procure in the agreement. So insofar as it affects the shares in his hands, the practical result of these arrangements is that no purchaser would buy without seeing that the terms of this agreement were either satisfied or by some other means brought to an end.
Yes.
My Lord, there is then what I call the alternative point. My Lord, I may have missed out in my plan that after looking at the statutory provisions, I'm going to take you to the authorities on market value in the context of estate duty.
Well, I'd assumed you would, yes.
But just been reminded by Manfrello Jr. that I didn't actually say that, but that's the plan. The alternative point, my Lord, is that if the shareholders' agreement creates rights which are not part and parcel of Mr. Gibson's shares, and I use that term in a technical sense, it's a defined term in the agreement. It's the shares issued to Mr. Gibson, rather than the shares he happens to hold, because of course he acquired other shares.
That's, you mean the further 258 shares?
Yes.
Just a small amount.
Small amount, but the definition in the agreement is Mr. Gibson's shares are the shares issued pursuant to the agreement,
Yes.
and that definition
Right.
would run with those shares past the fulfilment of the obligations in the agreement. So if the shares, and we'll look at the terms of the agreement, I say this is a possibility you need to be aware of, if those shares passed into the hands of another, various of the terms in the agreement would survive that passage. But anyway, we'll look at that when we come to look at the particular terms of the agreement. But if, my Lord, everything I've said so far is not accepted, then we say it follows that the rights under the shareholders' agreement are a separate asset from the shares. This is, in substance, the approach adopted by the majority in the Court of Session. And the way in which the majority explain how this works, it is that for his shares, Mr. Gibson receives what the Court of Session has said is the market value, namely the pro rata attribution of the total proceeds of the sale of the company. And in the way in which Lord Mackay puts it towards the end of his reasoning, in his opinion, he says it is the equivalent of a debt being satisfied by the other parties to the shareholders' agreement.
No, this is not an argument that you took below.
This
you were
is not
before
an
the
argument
special
we took
commissioner, so
below,
you didn't
no.
raise it at that point.
So, in respect of this point, we have to seek your lordship's permission to raise it at this stage. And I'm in your lordship's hands as to the point at which I do that, but I would prefer to do it after I've made all the other submissions, because it will be very much easier to understand how it fits into the structure of Part 7.
Well, don't let's take up time by debating the timing of it. As you know, Mr. Johnson objects to this on various grounds which are set out in his case, and the Lordships will require some persuasion that it's proper for you to raise this argument, but it may be better to make progress with all the other material first and leave it to the end. I'm a bit concerned about the pace at which you're going. We only have 2 days for this case, and we haven't been given, as we normally do, a timetable of how many hours you propose to take to present your case. Have you given thought to that? And if so,
I
how
have, my
many
lord.
hours?
I think I will take the rest of today and maybe a little bit of time tomorrow morning. But with luck, I'll finish today. My learned friend says that he thinks he'll need about 2 hours, and I should hope that I would need less than an hour to reply to his submissions if necessary.
Well, should we aim to get as much as possible done today, and if preferably finish your argument today, subject perhaps to the last point which you've mentioned?
My lord,
Very
I'm
well. Well, let's get back to
very
the
happy to do that.
menu, please.
My lord, if I can take you to Part 7, which is in Divider 37 of the Authorities Bundle. You'll also find it in the Part 1 of the Appendix, but in the Authorities Bundle you will find it, in Divider 35 in Volume 4 of the Appendix.
It's the identical copy, is it?
They are identical copies, my lord. But you will find behind Divider 36 the section of the Finance Act 2003 in which these provisions were enacted. So it's rather a strange history. The Income Tax, Employment and Pensions Act 2003 was enacted and came into force on the 6th of April 2003, but the provisions with which we're concerned were contained in the Finance Bill and Finance Act 2003 and replaced the provisions which had previously been in ITPA, the Income Tax, Employment and Pensions Act 2003, and they were enacted as a block in Schedule 22 to the Finance Act 2003.
Yes. I think we get a little head note in tab 35, just under Chapter 1, General, which explains why it's all in square brackets.
You do, my lord. The significance being that all these provisions we're going to look at now were enacted together as a code.
And they were amended, I think, in 2004, but we were not concerned with that, and we haven't got those amendments in this print. Is that right?
Correct, my lord. There I think, have been amendments nearly every year to little bits of these provisions.
What, since 2004?
Indeed, my lord.
But not before 2004?
Not before 2004. And my lord, none of the amendments go to the issue that you're concerned with today.
And the critical date from the Revenue's point of view is the sale in November 2003, which is why we didn't go further.
Indeed, my lord.
Right.
But lest you were concerned about the consequences of the decision going forward, they will be the same. They're not affected by any of the amendments that have been made subsequently. So, my lord, you will find, looking at these provisions, 417 sets out what's here, 418 related provisions, 419 a computation rule, 420 the meaning of securities, and for present purposes it's worth noting firstly that subsection 1A of 420 includes shares in any body corporate, etc. And then in subsection 8,
But, sorry, just as regards subsection 1, should we not note, at least in passing, that the definition of securities is very wide indeed, and is much wider than what many people would assume was meant by securities?
Indeed, my lord, absolutely.
Are you interested in head G in this particular case?
Not specifically, my lord. It is conceivable that might be an apt description for the agreement, and that would fall into the alternative argument point. But I was going to found the alternative argument point on subsection 8, and just to show the width of these provisions as well, subsection 8 provides that an interest in relation to securities or shares means an interest in them less than full beneficial ownership, and includes an interest in proceeds of their sale, but does not include a right to acquire them. And that last exclusion is there because the next definition is securities option as a separate category. And securities options are dealt with under Chapter 5 with their own separate code. If, my lord, you can hang on to the mental image of the definition of interest, we'll come back to it in a minute when we look at 421B. Section 421 then sets out the meaning of market value. Market value has the same meaning as it has for the purposes of Part 8 of the 1992 Act. And then 421A, the meaning of consideration. The section applies for determining, for the purposes of 2 to 5, the amount of consideration given for anything. 2, if any consideration is given partly in respect of one thing and partly in respect of another, the amount given in respect to the different things is to be determined on a just and reasonable apportionment. That provision is the foundation of the new alternative submission. And then 3, consideration excludes the performance of duties in connection with employment. And 4, no amount is to be counted more than once. Then 421B tells us that Chapters 2 to 4 apply to securities or an interest in securities acquired by a person where the right or opportunity to acquire the securities or interest is available by reason of employment of that person or any other person. So there we see the word interest cropping up again. So that's the alternative argument. And the rest of the provisions of 421B are, as one might expect, clarifying and extending the meaning of the scope of subsection 1, in particular what is meant by reason of employment. Subsection 2 expands employment to include former and prospective employment. Subsection 3 deems anything which an employee receives to be by reason of employment unless it's a domestic arrangement, and so on. And then, just to complete this bit of the journey, in subsection 8, there is a definition of acquisition and employment, but for our purposes, the important definition here is employment-related securities, because that's the phrase we find in the subsequent chapters, and it means securities or an interest in securities to which chapters 2 to 4 apply. It may seem circular, but that's a reference back to the provisions of subsection 1. So in effect, it's saying that the things to which subsection 1 applies are to be called employment-related securities.
Yes.
My Lord, if I may then take you to chapter 2, which deals with restricted securities.
Is it helpful to just look back to 417, because we get a sort of index there?
You do, my Lord.
I'm just wondering how many of this long list there you're asking us to have regard to.
I'm going to take you to chapters 2, 3,
Yeah.
and 3C and 3D,
Right.
and we will pass over 3A and 3B swiftly, but we will have a look at them. Everything else I will leave aside as not having a bearing on the issue.
Right. Thank you. Chapter 2.
2. At the page which is numbered at the top 8184, because of course the old chapter 2 is reproduced before the operative chapter 2 in this version. Section 422 applies the chapter to restricted securities or a restricted interest in securities. And then 423 defines what is meant by those terms. And there are two crucial elements in subsection 1. For the purposes of this chapter, employment-related securities are restricted securities or a restricted interest in securities. If A, there is any contract, agreement, arrangement or condition which makes provision to which subsections 2 to 4 applies, and we'll look at that in a minute, and B, the market value of the employment-related securities is less than it would be but for that provision.
I thought, where are you reading from?
Section 423.
No, it's this.
But, sorry, my Lord, this is page 8184. Because what the publishers have done is to reproduce the provisions which were enforced formerly.
Yes, thank you.
Because they continue to apply for some limited circumstances.
So it's the new 4231.
Yes, my Lord.
Yes, thank you.
So, restricted if there is any contract, agreement, arrangement or condition which makes a provision to which any of subsections 2 to 4 apply, and the market value of the employment-related securities is less than it would be but for that provision. Now, we see in subsection 2 that the provision will be provision relating to transfer, reversion or forfeiture of the securities or the interest on contingencies. As a result of those events, the securities will cease to be held, will cease to be beneficially entitled, the individual will cease to be beneficially entitled to the securities, or they will cease to be held, and that the person will not be entitled on transfer, etc., to receive in respect of them an amount at least their market value at the time of transfer. So this would cover the typical sort of provision which one sees on a daily basis on the issue of employment-related securities, a provision which provides for forfeit if the individual leaves within a certain period, and which provides that the individual cannot alienate the securities.
Well, sorry, you say you see them on a daily basis. It may be that you do, but I think you shouldn't assume that we do.
No, my Lord, but you'll be aware of the current public encouragement to employers who are rewarding their employees with large bonuses, that they should take the form of something other than cash. And so this is something which does happen all the time.
But, that is no doubt so, but you're not asking us to take judicial notice of whether it is usually done by something in the articles of a company or something in a service agreement, because I think...
Indeed, I'm not, my Lord. All I'm inviting you to notice is that these provisions are apt to catch that type of common restriction, however it's implemented. And they're apt to describe such restrictions wherever they're to be found, and that we get from subsection A, any contract, agreement, arrangement or condition which makes provision to which any of subsections 2 to 4 applies.
And in subsection 2, these heads are cumulative.
They are, my lord, yes. So subsection 2 deals with provisions which relate to transfer, reversion or forfeiture. Subsection 3 deals with provisions under which there's a restriction on the freedom to dispose or the right of a person to keep the proceeds of sale or to keep the securities, or any other right which is conferred by the securities. So just pausing there, if a restriction of this sort was contained in the security itself or its defining terms, it wouldn't be a restriction on a right conferred by the security. But if it's found somewhere else, in a contract or agreement, arrangement or condition, and it restricts some right conferred by the security, then it's in. It's caught by this provision. And subsection 3, my lord, subsection 2 was a set of cumulative conditions. Subsection 3, the types of provision there are in the alternative at the end of letter B. And then 4 is a sweeping up provision. It applies to anything which isn't covered by 2 or 3, and it applies to any provision under which the disposal or retention of the employment-related securities or the exercise of a right conferred by them may result in a disadvantage to the person by whom they're held, to the employee if somebody else holds the security, or to any person connected with them. Just pausing there, my lord. Pausing there, we say that the draftsman of this provision must have had in contemplation restrictions which were outside the articles and the governing documents of the company defining the securities in question. It is apparent from the language, in particular 3C, but also with the language in subsection 1A, that it's anything, not just the governing documents to which the draftsman is here referring. And the second important thing to note and this is at the centre of our case, is that in subsection 1B, it's clear that the draftsman contemplates that these things may affect the market value of employment-related securities. So, in this context, whatever market value might mean in the capital gains tax code, in this context, it's clear that the draftsman thought that market value was something which was capable of being affected by matters of this type, which could lie outside the securities themselves.
Mr. Cherry, here's a really silly question. I mean, I can quite see in relation to the shareholding of the others that they might fall into 4231B because the market value of their shares was less because part of any profit was going to go to your client and they were going to be paying it. But how does it work for your client?
Well, my lord, this provision doesn't apply to my client for two reasons. Firstly, well, it was enacted in 2003 and didn't apply to shares acquired prior to it coming into force. So it doesn't apply to my client's shares. But had he acquired his shares after this provision came into force, then it would apply. But the purpose of taking you to these provisions and explaining them in the detail that I am doing is to show you the scheme of Part 7.
Very well.
Because another provision in Part 7, which charges my client, even though he'd acquired before it came into force, contains the phrase market value. And what I'm going to endeavour to do is to demonstrate to your lordships that these various provisions are interlinked and interact with each other, and that it's because of that market value must have the same meaning throughout.
Looking at 4232C, that's 423 subsection 2 subparagraph C, the impression I have is that there will be a transfer from the vendor to the purchaser of something which can, to which a market value can be attached. That seems to be the assumption. So would it follow that the rights or restrictions that we're talking about here are transmissible to the purchaser?
Not necessarily, my lord, because as you will see, that A is talking about either transfers, reversions, or forfeiture.
Well,
and A, B, and C are cumulative. That person will not be entitled on, it may be either transfer, reversion, or forfeiture, to receive an amount of at least market value.
well, it's forfeiture gives rise to an assumption, I suppose, does it? I mean, is it that there's no actual open market transaction, but nevertheless somebody is having something taken away from him to which a value could be attached on certain assumptions?
And the assumption is, my lord, in B, the market value of the employment-related securities is less than it would be, but for that provision.
Yes.
So the assumption underlying that is that market value is affected by restrictions of this sort, which could include forfeiture.
Well, I'm sorry, I don't understand that. Why forfeiture should affect the market value? It gives rise to a need to assess value on the basis of market value.
Yes, my lord, but the assumption in 423 subsection 1b is that the securities will have a different value than the market value they would have if this restriction were not there.
Yes.
So suppose you have a security where if the employee leaves the employment, it is to be forfeit. And that restriction is to last for either the employee's employment or for 3 years, let's say. this provision presupposes that one can identify the market value of that security if it were not subject to that restriction, and that a restriction of that sort is capable of reducing its market value. Because, of course, market value may be realised, possibly, as a practical matter, or value, at any rate, may be realised otherwise than on a sale.
Do I understand that the revenue doesn't dispute the fact that these things are taken account of?
Indeed, the revenue avers that they are.
Yeah. They accept that.
And that's the point, my lord.
So, they say there's a particular reason it has to be so in Chapter 2, as I understand it.
My lord, the way these provisions then work is to be found in 428, and the way they work there,
Yes.
although the provision looks difficult, it is relatively straightforward. And if I may endeavour to explain how it works, in 428 subsection 1, there is a formula, and this gives rise to a charge whenever there's a taxable event. A taxable event occurs under 427 when restrictions are either brought to an end or expire or are varied. And 428, in the formula, says that the charge is by reference to UMV, and for present purposes, the shorthand for that is unrestricted market value. It's defined in subsection 2, but it's what would be the market value of the security if you ignored the restrictions. So, my lord, you just commented that the revenue accept that variations of this sort, restrictions of this sort, affect market value. Indeed, they do. And 428, again, presumes that they do, because what it does is to ask the question, what would the securities be worth without these restrictions, or any restrictions that are there? And you then impose a charge to tax by reference to the proportion of the original value which was depressed by the existence of the restrictions.
It's put quite neatly, I think, in the revenues case in paragraph 30 in the second sentence. I don't know whether you would agree with the way it's put there, but they say it works by establishing what proportion of the unrestricted market value of securities when they were acquired was not paid for at that time, and then applying that proportion to the unrestricted market value on the occasion of a later chargeable event. Do you agree with that?
Well, as a general statement, my lord, which tries to explain what it's about,
yes,
it may convey the gist, but actually, in quantifying the charges, it may or may not be what's paid for that is the crucial thing. It may also be what you paid tax on when you got the original securities. So the equation in subsection 3, which is IUP, the initial unrestricted premium, if you like, is arrived at by looking at the ratio of the initial unrestricted market value, deducting from it deductible amounts, and that would include what you paid for the security, but it might, on the other hand, be you paid nothing, in which case it would be the amount upon which you paid tax as a general emolument at the time you acquired the security.
That's spelt out somewhere in this paragraph.
Yeah, it is in subsection 7, my lord.
You said premium, did you? Would not proportion be better, or is premium an official word?
I'm using it by way of explanation,
But
my
I
lord.
mean, it is a proportion.
It is a proportion, indeed. And that may be a more felicitous term. In the formula in subsection 1, the other elements are only relevant if you're looking at a series of charges. PCP deals with amounts which have been previously charged proportion, and OP deals with an outstanding proportion where there are restrictions still in force which continue to depress market value. And CE is the expenses of the transaction which has triggered the chargeable event. So for the purposes of understanding how this works, what one needs to concentrate on is UMV and IUP. And subject to the caveat I just mentioned to my Lord in the Chair, the revenues formulation in paragraph 30 is helpful.
Sorry, I beg your pardon, is
helpful.
helpful, thank you.
But again, we see in subsection 2, in the definition of unrestricted market value, UMV, this is what would be the market value of the employment-related security immediately after the chargeable event, but for any restrictions, implicit that the restrictions which still apply affect the market value. And we know from 423 that may be things outside the articles. So
your point, you accept that it would cover provisions that were in the articles, but your point is it also covers provisions that are not in the articles.
Indeed, my Lord. And of course they have to have an effect on value, but it's clear that the draftsman here contemplates that matters outside the articles will do so because of the language he uses to describe where you might find them in 423A.
But it was partly with what was coming in mind that I asked you to confirm that the definition of securities is very, very wide. Because if you're talking about a contract for differences, whatever that is, you're not going to find the terms of a contract for differences in the articles of a company, are you?
No, but you will find them in the contract.
Indeed.
And so it's perfectly possible there you might have a contract for differences, so that might be a stop-loss provision.
But in deciding the value of the shows in action represented by an interest under a contract for differences, cases like Crossman are not going to be very much help, are they? Cases on the valuation of shares in private companies.
Other than setting out the principle that you're looking for the property in question.
Well, you're going to take us to
I'm going to take you to
authorities in due course.
But they inform the approach to identifying the property in the context of estate duty, which is helpful to explain what the correct approach is to restrictions.
Well, my Lord, sorry to interrupt you, my Lord in the Chair commented it was a 1992 definition. In fact, it's a 1965 definition as far as capital gains tax is concerned.
Indeed, my Lord.
And it's an 1894 definition so far as you go back to estate duty, isn't it?
Indeed. Although clearly there are some wrinkles in the capital gains tax code which suggest that there may be a difference between there and the estate duty code. But before leaving chapter 2, there are two further provisions I would like to draw your Lordship's attention to in particular. In section 425, there is a relief, a tax exemption, when an employee acquires a restricted security and the restrictions are going to last no more than 5 years. You see in 425(1)(b) will cease to be restricted securities by virtue of 423 within 5 years after acquisition. And where this applies, subsection 2 provides there to be no liability to income tax in respect to the acquisition, except as provided by Chapter 3, so that deals with any conversion rights which may have been exercised on the acquisition in order to acquire the security you're looking at. So if it were converted from something else. Skipping B, Chapter 5, acquisition pursuant to an option, so any charges under Chapter 5 because you've excised an option to acquire the security will still be in place. And paragraph B, Chapter 3C of this part, acquisition for less than market value. So if the security falls within this provision, no tax at the beginning, but you do have tax under 3C. And I want your lordships to hang on to that point, which will I'll make the significance of it when we come to look at 3C.
You won't ask us to hang on to too much, will you? Because you are showing us all this just to make your point really about market value. And we really don't need to go into all the complexities of this, do we?
Well, what you do need to understand, my lord, is that these provisions are not isolated provisions, but they're part of a code which articulates one bit with another.
And which is so complex that in 6 years this is the first case that any taxpayer has ventured to litigate it at all.
It's the first case which has got this far, my lord, although of course the dispute has been going since the very beginning, and since 2003. That's the 6 years just illustrates how long.
But there isn't any other reported case at any time.
There are no other reported cases on this point, my lord, at all.
I'm trying to keep pace with what you're saying and what the revenue say in paragraphs 30 and following. Paragraph 31, halfway down, it said the whole rationale of Chapter 2 depends on taking account of restrictions personal to an employee. And that seems to be so. Is that not, at least in this case?
Well, they may be personal, they may not be personal. They may be apply to a group of people, they may apply to a class of people. The provisions are the definition in 423 is so wide.
Right.
For example, to give you an illustration of one of the circumstances where the revenues say these provisions are theoretically in point, most private companies, like the one that we're looking at here, have a provision which gives the directors a discretion to refuse registration of transfer. The revenues say that is a restriction which triggers these provisions. So that would be a completely impersonal one found in the articles.
Well, where do we go from here?
Section 431, before leaving Chapter 2, my lord, I just want to show you this because it is important. If you have a restricted security, and instead of paying tax when the restrictions are lifted, you would rather sort it all out at the time you get the security, then you may so elect under Section 431. And you'll see in subsection 1b, if you do so, sections 425 to 430 are not to apply to the employment-related securities.
Yeah.
And then, in subsection 3, I define the relevant tax purposes which this election applies for, determining 3a, determining any amount that is to constitute earnings for the employment under Chapter 1 of Part 3. So that's the general charging provision on earnings, section 62. And so what's happening here is, although you've got a security with an open market value unrestricted of, let's say, 100, it's quoted on the stock exchange, but you can't sell it for the next 3 years. So it's restricted for the quantification of a charge to taxation on earnings. Let's say it was given to you for free. You wouldn't take the 100 because you can't convert it into 100. What you would take is what you could convert it to. And that may not be necessarily on a sale. And let us assume, for present purposes, that by one means or another, you could, maybe by granting an option or something, you could yield 75 from it now. That would be the amount that would be taxed under general earnings as a matter of general principle. What's happening here is that if you elect out of the charge under these provisions, when the restrictions are lifted, you find that the charge on your acquisition is treated as though you've got the unrestricted market value, so the value of 100. And then you see again two subsections further down. If that doesn't cover everything, Chapter 3C operates as though the security was worth 100 when you acquired it. Chapter 3C deals with acquisitions at an undervalue. Chapter 3D, with which we're concerned, deals with the other end, disposals at an overvalue. And finally, in the definitions in 432, subsection 2, market value has the meaning indicated in 421. So that simply confirms what we saw in section 421, that it applies for the purposes of all these chapters.
Yes. So we go to chapter 3, you say, convertible securities.
Indeed, my lord. And now we can perhaps pick up a little bit of speed, because we see in 436, for the purposes of this chapter, securities are convertible securities. Excuse me. If they confer on the holder an immediate or conditional entitlement to convert them into securities of a different description. B, a contract, agreement, arrangement or condition authorises or requires the grant of such an entitlement. So that's clearly not in the security itself, that's something else. Or C, a contract, agreement, arrangement or condition makes provision for the conversion of securities otherwise than by the holder into securities of a different description. The point is that this chapter is again concerned with matters which stand outside the articles or the governing instruments defining the terms and conditions of the security in question. And the way this provision works.
Yes, sorry, again I'm looking at paragraph 32, the revenue, except that the chapter is concerned with any such entitlements conferred upon the holder, be they personal to the holder or inherent within the securities themselves, and you're stressing the first branch of that.
And they could be extrinsic to the securities and not particularly personal to the holder.
Yes, I see. Yep.
Yep.
Yes.
So what these provisions do is to take the value attributable to that conversion out of the market value of the security at the time you acquire the security for the purposes of quantifying your tax charge at the time you acquire the security. And we see this in 437.
Can I just go back to the word personal, just to be quite sure? I mean, I'm sure Mr. Johnson will explain what he means by this, but it strikes me he may be using the word there in the phrase, in the sense of, if one can use the Scottish expression, a personal right as opposed to a real right. Do you understand?
Yeah, I do.
So it's something that would remain with the holder and would not transmit, I think is what he may be getting at there. And that would be right, wouldn't it?
Well,
I mean, it may be shared with other people, in that sense, not personal to him, but it's not something that the person who acquires, let us say, a share to which the Articles of Association apply, would take the share together with what the Articles say.
he would, but in that circumstance, para A would have apply,
Yes.
436A. The securities themselves confer on the holder an immediate or conditional entitlement to convert them.
Yeah.
So this provision is looking at things which are in the defining terms of the security, whether if it's a share, then in the articles, and outside, and it's treating them in the same way.
Yeah.
And the way in which it does that is in 437. So, for the purposes of any liability to tax under Chapter 1 of Part 3, so that's the general charge to earnings, so assuming you've got the security for free, let's say, also for the benefits rules, also for the options rules, and B, the operation of Chapter 3C again. Acquisition of securities for less than market value. The market value of the employment-related securities to be determined as if they were not convertible securities or an interest in convertible securities. So that would apply whether the conversion rights are personal in the sense that you've just used, my lord, or in rem. And again, it presupposes, the draftsman here presupposes that the market value of the convertible security before this operation is carried out on it reflects the right to convert, whether it's inherent in the security or whether it's collateral to it.
Yes, the revenue attach importance, I think, to what we see at 437, the last two lines, the market value is to be determined as if they were not convertible securities or an interest in convertible securities.
Indeed, my lord, and that's the very point we're making.
Yes.
What we say, that's crucial.
Yes.
These provisions contemplate that market value is affected by the right to convert wherever it is found. It's at the heart of our case. So this mirrors the provisions about restricted securities. And the articulation with Chapter 3C to be found in 437 is consistent with market value there being ascertained on the same basis and being directed by 437 to be adjusted if the adjustment here applies.
No. Are we going to 3C straight away, or do you want to
We will be going to it once I've just drawn your attention, my lord, to two other bits in Chapter 3.
Yes.
So Section 440 is the provision which tells you how to compute the charge here. The charge arises when you exercise your conversion rights. And the gain is ascertained under 441 and involves a comparison between the market value of the securities into which you converted and the market value of the securities which you had beforehand.
Can you just go through the acronym? CM.
Current market value of the converted securities.
CS means?
I think converted securities.
And then ERS.
So you find that in subsection 6A, my lord.
Oh, I see. We've got the key. Yes, thank you very much. Yes.
And then CMVERS is the market value of the security before conversion as if it were not convertible.
So what is the spelling out of that acronym then?
Well, that's current market value of employment-related securities.
Oh, I see. Yes.
Sorry,
Thank you
my
very
lord.
much. It's not, it doesn't-
It's extraordinary that instead of actually using words like that,
Yes.
the legislation just uses the acronym and then
Yes.
defines it.
Yes, it hardly leaps off the page, but I see what
It
you
doesn't, and that's one of the reasons why I suspect the Special Commissioner was not keen to get involved in these provisions. They are not easy. The concepts are not too difficult, but the detail is extraordinary.
But this one, I'm not sure that this one helps you so much, as I'm expressing the most tentative possible view, but what 437 is doing here, and it is headed tax relief on acquisition, isn't it simply saying whether the right to convert is in the articles or is in something extrinsic, just forget about it, treat it as not convertible. Isn't that what it amounts to?
When you get the security.
When you get it, and then we look at 440,
Yes.
and they say all the benefit of conversion, wherever it comes from, whether from the articles or extrinsic, we tax at the time that you actually get the benefit from it.
Indeed, but in both cases, what's happening is the market value is being adjusted. The mechanism by which these provisions operate is to say, in 437, after paragraph B, the market value is to be determined as if. So it presupposes that the rights we're talking about affect the market value of the security.
Well, you wouldn't accept it presupposes that they may
Sorry,
affect.
I would, yes.
I mean, that's the only point I was making, that,
Yes.
that it's, I mean, this seems to me somewhat easier to fit into a coherent scheme than 4.2. The one that you showed us on chapter 2.
423.
4231B.
Yeah.
That's the one you wrote.
But both of them, my lord, have this phrase, contract, agreement, arrangement or condition.
Yes, I see that.
And so it's clear that what the draftsman is doing throughout here is not making a distinction when he's talking about the market value of something between rights or restrictions, depending upon which chapter you're in. He makes no distinction between those found in the defining documents defining the security and those found elsewhere. They are both, wherever they're found, they affect market value, and that is presupposed. And you get that again in 441 in those definitions of the current market value of the convertible security and of the employment-related security, both valuations which are in relation to the employment-related security. The old security is a hypothetical one, and then the destination security is the actual market value.
Now, there is a difference in the definition of... No, there isn't, I beg your pardon. The market value is defined in exactly the same way in section 4442.
Indeed, my lord.
As it is in the previous one. So we're taking each time back to the definition, which in fact we find when we reach it in 3D.
Exactly, my lord. So all of this is the same definition, and the way in which, as I showed you in 437B, the way in which these hypotheses operate is carried through to 3C as well. So, my lord, if you assume you've got a security, let's say a convertible preference share, which is worth 100, because the ordinary share into which it can be converted is worth 100, but you've also assume its market value would be, let's say, 75 if it didn't have the right of conversion. Yes. Then what this provision does is to say when you get the security, you'll be taxed as though you've got something worth 75. And then if you convert at a later date, we'll look at the comparison at that stage between the value of the new security and what the old one would be if it weren't convertible. So let's suppose values don't change and a year later you convert, you'd be taxed on the further 25. Instead of being taxed on £1 at the beginning. But the consequence of 437 little b is that reduces the amount that you might be charged on an acquisition at an undervalue by Chapter 3C. So if you've paid 75 for a security which is actually worth 100, and you might otherwise not be able to turn it into money's worth because of something else that's going on, but the market value of the security is in fact 100 if it is convertible, then what this does is to bring the market value down for the purpose of the charge under 3C. So these provisions which interlink with 3C are moving the tax charges around between these two chapters and 3C on acquisition, and yet market value is used throughout as having the same meaning, and it is plain from what we've looked at so far that meaning encompasses value being affected by things which are personal or may be personal. My Lord, if I can then just draw to your attention the titles to chapters 3A and 3B, without taking you to their mechanics. Chapter 3A is a code which deals with securities with artificially depressed market value and imposes tax charges on acquisition, and where in certain limited circumstances you've got restricted securities which have had a depressed value, then that might reduce the tax charge under Chapter 2, so there's a tax charge here. Just the only provision I want you to note here is that, again, 446J on page 8197, it's the same market value definition again.
Yes.
And then Chapter 3B deals with securities where the value is artificially enhanced. This doesn't charge you when you get the security, but charges you when you dispose of it, or on a 5th of April, if you still hold the security then. So this is the complement to Chapter 3B. And again, in 446P, subsection 2, market value is defined in the same way. Then, my Lord, if we go to page 8200 in the top of the page, we come on to Chapter 3C at the foot of that page, and we get the scope of Chapter 3C. My Lord, do you have that 8200 on
Yes.
that page? So 446Q subsection 1, this chapter applies if no payment is made for the security at or before the time it's acquired, or B, the payment made is less than their market value.
Yes.
And the way this provision works, my lord, is that when you acquire securities for less than market value, and we'll see at 446W that market value is defined again in exactly the same way. These provisions treat the employee as though they've received a notional loan equal to the undervalue, and then, and that's under 446S, quantified under 446T, and in this respect, my lord, if you're looking at the Crown's written case at paragraph 33,
Yes.
in the second sentence, the Crown say, in the first sentence they say Chapter 3C is concerned with securities acquired for less than market value. Indeed, just as in 3D, Chapter 3C compares the value. Actually, here it compares the cost
Sorry,
of the market value of the employment-related security with their market value.
you said cost is the proper word, do you?
Well, cost, payment, whatever, but it's not value. So in 446Q, either you've paid nothing, 446Q sub 1A, or B, you've paid less than the market value. So that's what's being compared. And you find that expanded, that comparison expanded in 446T. Market value minus DA deductible amounts, which are set out in subsection 3.
So there's an assumption of a notional loan of the amount of the difference
Yes.
between cost and the notional market value.
Well, this
or the
is
market value, indeed.
This is market value at
Yes.
large. There's no restrictions
Right.
on this, but we say because of what we've seen before,
Yes.
we have to read it in light of what we already know about the way the draftsman uses the phrase market value.
So this particular chapter is in a way the mirror image of 3D, is it?
Absolutely, my lord, and that's the point. The provisions we've been looking at, chapter 2 and 3, move tax charges from the acquisition of the security to a later point when the restriction's lifted or where the conversion right is exercised.
Jay, I mean, just so that I try to be clear in my own mind, is your argument basically that because we see in 423 and in 436 reference to outside agreements and so on, and you say that they are ex hypothesi in those provisions are taken to affect the market value?
Or to be capable of affecting.
Capable of affecting the market value. Ergo, therefore, when we come eventually to 3D, even though there's no mention of such things, nonetheless, you say they are also to be taken into account as potentially affecting the market value. Is that what it all amounts to?
And it's not just simply because of that, but also because those provisions articulate with 3C, they move the charge around and move the market value around at the point of acquisition, and 3D is the mirror of 3C. And so, although there's no explicit connection with the earlier provisions, the scheme is clear. And it is a single scheme. And with that, the Crown appear to be in agreement.
Well, let's look at 34 in the Crown's analysis. First sentence, in all of these comparative exercises, so we're looking at the entirety for this purpose, the personal rights or restrictions find their expression in the actual side of the ledger and are excluded from the market value or notional side.
Well, my lord, that just doesn't make sense.
You don't agree with that, of course.
Not at all. Because in Chapter 2, as we've seen, the drafting presupposes that these restrictions affect market value. The provisions just misfire completely if that's not the case. Or at least they don't misfire completely, but they do misfire in a very substantial way. If in Chapter 2 market value is not affected by personal rights, then you can choose whether or not you're inside Chapter 2 by either putting your restrictions in the articles or in a collateral contract.
But is the revenue right in saying that one really needs to see what this is all relevant to? And what is really being sought to be charged is, as they put it, the personal premium, if any, by which the employee may profit from the security. And that may happen in a whole variety of situations, of which we see the headings setting out the examples.
Indeed, my lord. But if it's right that these personal factors feature in the taxation, the ascertainment of market values in Chapters 2 and 3, and by necessary implication 3C, then if I acquire a security which has rights attached to it, that will increase the market value of the security at the time of acquisition. And I will pay tax either under general principles or, if that doesn't catch me, under 3C as a result.
I don't see how 3C helps this argument, because 3C, the simple case where 3C applies, where it's not overlapping with and duplicating one of the others, is nothing about special rights, forfeiture or anything. You simply give ordinary shares to an employee and he doesn't pay anything for them.
Indeed,
and that is treated by saying, as long as he owns them and they're not paid for, you treat it as a notional loan and tax it under those provisions.
And, my lord, when the employee sells the shares, that's caught under 446U.
And then you treat the notional loan as being part of his employment income for that year.
Yes.
And that is reasonably easy to understand. And does it help your argument at all?
Just taking the case where there are no rights attached at all, it doesn't take us further or backwards one way or the other. But what I say is that if we have a security such as we have here, and there are rights attached to it, which, let's say, they may include a conversion right, which would be within Chapter 3. It's not necessary, but... and let's assume that security is actually worth 100 when we get it. Now, either we pay 100 or we suffer a tax charge under 3C. Now, if the right way to ascertain market value at that point, that 100 is ascertained taking account of the rights that have come with the security, then it must be must be the case that it would be wrong to tax those rights again when we dispose of the security together with those rights or realise their value under 3D on the basis that the market value of the security excludes the value of those rights.
I'm sorry, you lost me because I was trying. This is enormously complicated. I mean, it's easy to make it complicated. I'm trying. Just 3C. The paradigm case of 3C is where we're not into special rights or conversion. It's simply the employee gets something, an ordinary share, and doesn't have to pay for it. I mean, you accept
it covers that case, certainly, my lord.
And, well, the likelihood is, if it's one of the more complicated cases, the revenue will go under that, and they won't try and hit him under 3C as well, will they?
Well, my lord, if you take our case, where we've got a right to a specific sum of money on contingencies occurring in terms of disposal and so on, those rights wouldn't, I think, fall to be taxed under the conversion provisions here.
You have to go to 3D.
So on disposal, but 3C is all about acquisition, and the two are linked because they must mirror each other, otherwise you get effectively the same thing being taxed twice.
Are they mutually exclusive?
Well, one applies at acquisition, one on disposal, so they're not mutually exclusive. They could tax the same thing twice if the way in which you ascertain market value is different under the two provisions. And what I've endeavoured to explain so far is that 3C market value has to be the same as chapters 2 and 3 because they interlink. And if 3C market value includes, let us say, a right to sell your shares on a certain contingency, so includes, let's say, a put option, which is not part of the security itself, for the sake of argument, but is nevertheless a collateral agreement. And if I'm right, that chapters 2 and 3, when they're talking about market value, assume market value includes collateral agreements, then when we get to 3C, it must do so as well. So if I have a share worth 100 and a collateral agreement worth 100 given to me, then 3C would operate to tax me on acquisition on 200. And if the values don't move and I sell the security for 200 and the put option comes to an end on that exercise, under 3D, if the market value is confined to the security itself and not the rights over it, then I get taxed on 100 again, the value of the option. So what I'm saying is the basis for ascertaining market value under 3C has to be the same, unless subject to one of the specific adjustments which 2 and 3 provide for, has to be the same under 3C and 3D. Otherwise, there is likely to be taxation of the same thing in a different way under the two provisions, and possibly the same thing being taxed twice. That doesn't fit in with the scheme.
Well, I can follow that as far as 3C and 3D are concerned, but at the moment, can you just go back to the provisions that you asked us to particularly watch, which is, an example is 437B, I think, where we see an express reference to the operation of Chapter 3C when we talk about the adjustment of the charge. So there it is. We now see 3C.
Yes.
Can you just explain how that provision is intended to work?
So 3C would otherwise be looking at market value, simpliciter. 437 tells us that we have to take out of market value the conversion rights which Chapter 3 deals with. Those rights include, as we can see from 436B, things which are collateral, personal, or may include them.
Yeah.
So it's clear that the scheme of this legislation envisages that market value in Chapter 3C will take into account similar personal things, or may do, erstwhile, the adjustment here, which is an adjustment from the actual market value of the security as together with its conversion rights to the value shorn of the conversion rights, wouldn't work properly. If the measure is not the same in both places, this interaction won't work properly.
And 437 is headed tax relief on acquisition, which is an interesting heading. So it's suggesting that but for that, there would be an additional penalty to tax under chapter 3C.
So the example, my lord, would be you have a share,
Yes,
and you have
a conversion right.
a conversion right attached to it, and the conversion right means that the value of the share, simpliciter, let us say, a preference share is worth 75, but because you can convert into ordinaries, it's worth 100.
Yes.
The charge under 3C would be on 100,
Yes.
because that's what the thing is worth, without this relief, which brings it down to 75. Why does it do that? Because it's going to charge that 25% at the time of conversion under Chapter 3. Now that conversion right, we know from 436, may be either in rem or personal, collateral. We say the scheme, therefore, is that such rights, whether they're in rem or personal, are the measure of market value in both places. And if that be right, given the relationship between 3C and 3D, which is that one taxes on acquisition, the other on disposal, market value in those two places must mean the same thing too.
Why don't we find a reference to 3D in 437?
Because 437 is dealing with the adjustment of the charge on acquisition.
Yeah. Well, I mean, that's plain enough on the heading. It's certainly true. But,
because at that point, 3D doesn't apply. It only applies on disposal.
Applies on disposal.
And that's why the linkage through to 3D is via 3C. That's why 3C is dealt with here explicitly. On disposal, if the right is still there, then it's a chargeable event under these provisions anyway. And both 3C and 3D apply in a residual manner, charging things which aren't otherwise charged.
Is it right to look at the exclusion, the tax relief on acquisition in 437, as a somewhat limited qualification? If I understand your analysis, while it makes you assume that they were not convertible securities, there may be other things which are of not an in rem or a personal nature, which they're not taken out, but are nevertheless included in market value.
Indeed, my lord. So, had our securities been acquired, for example, after these provisions came into force, they would undoubtedly have been restricted securities, whatever view you take about the shareholders' agreement, because there are provisions in there which restrict the ability to dispose. So there would have been an interaction between Chapter 2 and Chapter 3C on the acquisition of the securities. But subject to that, all the value in those rights at the time of acquisition, we say, is in the market value in this scheme, taxable under 3C regime by reference to the acquisition, and therefore shouldn't be taxable again on disposal under 3D. Why not? Because it's the same measure of market value and those rights are in there again. It's all consistent.
Yes. So going back to your scheme.
So we were in Chapter 3C.
We're going to 3D.
I very quickly mentioned to my Lord Walker that 446U charges the notional loan, the amount of the notional loan at the time of disposal. So the way 3C works is not to give you a tax charge on the undervalue at outset, but to treat you as though your employer had lent you the undervalue at outset and then taxes you on disposal. And market value, I've already pointed out to you, is the same. And then over the page in Chapter 3D, a very simple provision. And you see in 446Y the amount is basically what you get less the market value, less anything you spent on the disposal. And then in Z, subsection 1, market value has the same meaning.
Yep. I think you were going to take us to the 1992 Act, is that right?
I was, my Lord, but just before doing so, you've been tracking what the revenues say in their statement of case about all this.
Yes.
And so if I may very briefly come back to what they say, because we say that there are some elements of this which just don't tie up together. So the first sentence in 31, very briefly, the basic notion underlying Chapter 2 in relation to restrictions is that it is inappropriate to tax an employee on acquisition of his securities where his interest in them may be defeated. Yes, save where he elects, but what is not being taxed is the market value, the actual market value subject to the restrictions.
That's what he would be charged on, you say, if he didn't elect.
Indeed. In paragraph 33, your Lordship already has my observation about the second sentence. The reference to value there is cost or payment.
Sorry, I missed that. Cost?
It's in the second line of paragraph 33. Second sentence says, just as in Chapter 3D, Chapter 3C compares the value of employment-related securities with their market value. Well, in the case of 3C, it's the cost
Or cost, if any.
if any, and in 3D, it's the proceeds. But in both cases, it's the same methodology to arrive at market value. And then in 34, the first sentence in 34 is really very difficult. In all of these comparative exercises, the Crown say, the personal rights or restrictions find their expression in the actual side of the ledger and are excluded from the market value or notional side. Well, what I've been endeavouring to show, my Lord, is that the starting point in Chapter 2 is that market value is affected by personal rights or restrictions so far as the draftsman is concerned. He presupposes it is, and similarly, likewise, in Chapter 3. So the personal rights or restrictions are in the market value, and then those chapters adjust that for their particular purposes and have a knock-on adjustment into Chapter 3C. So that this statement just doesn't make any sense. It doesn't accord with the scheme at all.
Yes.
And that paragraph, that sentence, goes to the core of the revenues case. They seem to be saying something that the market value is not the actual value, that it's something ethereal. It just doesn't make sense. They equate market value to notional values. And that's not what it is. The starting point is market value. Yes, there are adjustments in chapters 2 and 3, but the starting point is market value, and the draftsman's starting point is that that is affected or capable of being affected by collateral rights, by personal rights. My Lord, if I may now take you to the Taxation of Chargeable Gains Act.
Yes, please. We're still in volume 4 of the authorities, are we, for this?
We are in divider 37. And section 272 is the provision which we're primarily concerned with, subsection 1. In this act, market value in relation to any asset means the price which those assets might reasonably be expected to fetch on a sale in the open market. And as my Lord Walker has already observed, that wording is very, very close to the 1894 wording in the estate duty legislation upon which we have some judicial guidance. My Lord, I've just realised there is one point I should have made before going to that, and I'm very sorry, if I may, just very quickly, and given the time, maybe I can deal with this point before lunch. If you turn to divider 38, so just over this page.
The frequently asked questions.
Yes. I'll make a submission later about the relevance of these, but I would just like to draw your attention, my lord, to two of the questions and answers here. The first, and if you turn a couple of pages to page 5 of 11 in the top right-hand corner.
Yeah.
Question 1K. Market value is now based on the capital gains tax definition. Does this mean that personal restrictions on the share no longer have to be taken into account in arriving at its value? So these are questions relating to Chapter 1 of Part 7 that we've been looking at, and so the meaning of market value, which is imported into all of the other chapters. So, do we ignore personal restrictions? Answer, no.
So it's as if an assumption is made that the restriction would apply to the hypothetical purchaser. It is the asset as it is, i.e. in the hands of the vendor, I suppose.
Indeed, my lord. And it is, I venture to suggest, partly because of this very clear statement that there hasn't been much litigation on this point.
Do we get any help from question 2S, which isn't in the bundle?
I do have 2S, my lord. But before I go there, my lord, can I just take you to another couple of questions and answers just below K? Question 1M. The Inland Revenue has confirmed that market value will take into account personal rights and restrictions. Personal rights, my lord, mentioned here, and not just those rights and restrictions attaching to the shares. Can you confirm that this interpretation of market value will be applied consistently throughout Schedule 22, which of course was all the new provisions that came in on the 16th of April 2003, 10 days after ITEPA came into force, and that you will not adopt a different interpretation for each chapter of Part 7? Answer, market value will be determined on a consistent basis throughout chapters 1 to 5, Part 7. So this accords with our submissions.
Yes.
You asked, my lord, about question 2S.
Sorry, I thought you said you had two other references. It's just Q1M.
1M, sorry, I beg your pardon, my lord. And just to note, N.
I see, you're right.
That they confirm that the information rules
Yes.
reflect through, but I don't think there's anything too contentious about that.
Yeah.
You'll find over the page, however, so on page 6 of 11, they've said at the foot of page 5, market value is determined in accordance with 272, which provides additional rules for quoted securities. For unquoted securities, 273 sub 3 provides an additional rule on information in the following terms. It shall be assumed that in the open market which is postulated, there is available to any prospective purchaser of the asset in question all the information which a prudent prospective purchaser of the asset might reasonably require if he were proposing to purchase it from a willing vendor by private treaty and at arm's length. So, but that's just a quote from the statute. The submission that, of course, is that that information would include the terms of the subscription agreement, the terms upon which the shares were issued, and of course it would include the existence and the terms of the sale agreement.
Yes.
You asked, my lord, about question...
Yes, is this very quick? You can do this.
2S.
Yes.
I don't know, my lord, but I have it here, so...
Or do you better do this after lunch?
I think, my lord, it might be easier if we dealt with this after lunch.
Yes.
Because I fear that this is This is quite an involved answer.
Oh dear. I don't want to cause difficulties, but let's do it as quickly as we can after lunch, and we're still hoping that you'll get very substantially through your argument by 4 o'clock.
I hope I will too, my lord.
Thank you.